Swayam Prabha. Digital India. Educated India.
A very warm welcome in the 5th module of week 6 of the course Roadmap for Patent Creation, titled Identification of Inventor and Applicant and Their Rights. So, to understand this, we will go first through some important sections and some definitions which are given in the Indian Patents Act. So, let us start. Now, if you see who are the person who are entitled by law to apply for a patent, then there are some, what we can say, the categories are there. It is given in section 6 of the Act. What it says, that a person who is a true and first inventor of the invention, he can apply for patent. So, the two word important, that is a true and a first inventor. So, the person who really have invented that particular thing, he has the right, and he should be a first person, that is a first inventor of that invention. Obviously, it will be a group of person. The meaning is not that that is a that first inventor means not necessary that in the group that first person, it is not like that. A whole group or a person, whatever the condition or whatever the what we can say condition might be or scenario might be, all this what we can say that they can apply for a filing that patent. So, true and first inventor is very important. Second thing is that any person who is assigned by the true and first inventor, he can apply for that patent. So, the inventors, for example, if any inventor is working in an organization, MNC, or in the academic institute. So, for example, if faculty is working in IIT or any faculty is working in any engineering colleges, generally in that case, as the invention whatever is there, it is generated by using the resources, and probably there are always policies for that to decide on who is inventor and who is a assignee. Already it is mentioned in the policies, probably in that particular college they may have the IP policy and it is determined. In the organizations, obviously there are policies, and by default in most of the organizations, rather in every organization, the scenario is that always assignee will be the organization and inventor will be that the person or individual who are inventing that thing. So, person who have invented that thing, so suppose faculty of IIT, he or she has invented something, they will assign that, inventors will assign their rights to the assignee, that is the Indian Institute of Technology. So, you will see always assignee as a IIT, right. So, here what the thing is happened, the assignment has happened from inventor to the assignee or to the applicant, and because of that, that assignee or that applicant can file the application, right. So, just understand the difference between that inventor here and the assignee is there. Okay. So, first, that is a true or first inventor, then what we have seen that the assignee, that is the first or true inventor, have assigned the rights. Okay. Now, the third, that is a legal representatives of the deceased true or first inventor, they have the right. So, obviously, it is a property, IP is a property. So, who are the, what we can say, the legal representatives for that property, if that true or first inventor have given that rights to legal representative, then obviously he or she can file the patent. So, these are the three main, what we can say, the categories or the persons, what we can say, who are entitled to apply for a patent. Okay. Now, we know that there is a first to file rule is there, right. So, the first person to apply for patent is entitled to get patent, obviously, and although means suppose what the thing happened that somebody have invented that thing, and if he will not file the patent, obviously he will not get that patent, right. So, that first to file is very important. Now, where to file patent? We know that there are 4 patent offices. In that 4 patent offices, according to jurisdiction, the patent will be filed. It may be Delhi, Mumbai, Chennai or Kolkata. Now, this application, what we can say that according to jurisdiction, according to the rights, right, the persons who are entitled, they can use online process or they can do the physical filing. It depends on the route which is chosen by that, what we can say, the inventor or the assignee, right. Now, the patent law allows applicant to file application, right, either they can consider the address of residence or they can consider the address of business. So, that will determine the jurisdiction. Okay. And obviously, the applicant will be the either Indian national or if or a national of a conventional country. Both have the right to file the application in the Indian Patent Office. We know what is that conventional countries are, and we have seen that national treatment is given to the members of that Paris Convention, right. So, the applicant may be the Indian national or he or she might be from a conventional country. And all foreign applicants, if they want to file patent in India Patent Office, what they have to do is that they have to use the place of business. If they have, they can just consider that place and that will determine the jurisdiction, or if that kind of place is not available, then through patent attorney or the patent agent they can file the application. So, this is what about the where to file a patent. Now, the next is grant of patent and register of patent. We have already seen how the process for granting is followed in the patent office, and we also know that how the registration of that patent, once it is granted, it happens. Just to revise that thing, what happens that the patent or whenever it will be granted, it will be after examination, when it is what we can say considered for the grant, what the thing will happen, that will be published in the register of that gazette. It will be published, it will be available in the register of patents, right. Now, obviously, the date of that grant will be mentioned. Okay. So, that date of grant, that whatever the details of that patent are there, everything will be mentioned in that register. The controller will publish the fact that the patent has been granted, and thereupon the application, specification, other documents related to thereto will be open for the public inspection, right. Now, in order to identify the inventor or applicant, anyone can look into these documents and then they can understand that okay, who is a inventor and who is a applicant, right. So, what the procedure is happening is that okay, the out of that 3 whatever categories we have seen, that true or first inventor, then assignee is there and the legal representative is there. They are filing the patent, then in the where they are filing the patent, according to jurisdiction they are filing the patent, they are following the things, and after that the examination will be there and then the grant will be there. Whole procedure is followed, patent is granted, and now it is what we can say published as a grant, the patent is granted and the whole details are available online, right. That details are available, and there you can find out who is the inventor and who is a assignee. Now, what are the rights? We have to see that okay, who that inventor and assignee, we understood now that okay, you know now where you are going to identify that who is the inventor, who is the assignee, right. Now, what are the rights given to them, that we have to concentrate. Now, before going into that about what are the rights, we will see the important definitions related to that. So, what is the meaning of a patent according to Act? It is a what we can say any invention granted under this Act, that is a Patents Act 1970. So, all definitions related to what we can say whatever we are seeing that patent, everything you will get in a section 2 of Indian Patents Act. So, according to this, whenever we are talking about a patent, what is the meaning of that patent according to Act? It is any invention granted under this Act. Okay. Now, what is an invention? We have seen that definition is a new product or a process involving an inventive step and capable of industrial application. We have seen all that words, that what is inventive step, what is industrial application, everything we have seen that in detail. What is the inventive step? It is a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, that makes the invention not obvious to a person skilled in the art. We remember Fosita, person having ordinary skill in the art, and accordingly we have seen the non-obviousness, and we have seen in detail what is that inventive step and what are the indicators for that, that also we have seen, right. So, we know what is patent according to act, we know what is invention according to act, we know now what is inventive step. Now, what is a person? We have seen that persons entitled to file a what we can say, to file that patent. So, according to act, person includes government, right, which, so I have just what we can say, I want to share this, or you request you to note that thing, person, it includes the government also. Okay. Then who is a true and first inventor? We are saying that okay, true and first inventor is entitled to file the patent. According to act, this true or first inventor is that what it is not, you have to just understand that first thing, does not include either the first importer of the invention into India or a person to whom an invention is first communicated from outside India. We know that the person who have invented that particular invention will be the inventor. He may be an individual, he may be a group of 5 people, he may be a group, that inventor might be a group of 10 people, whatever it may be. So, they are actual that group who have invented that, they are the first what we can say invented that particular thing, and they are a true what we can say they are the inventors of that particular invention. So, sometimes what you say that okay, if somebody imports something which is a novel to that particular country, suppose something is not available in India and that new thing is imported by some person, that is a first importer, whether he is an inventor? No. Inventor, first importer is not an inventor. Inventor is one who have invented that thing. He may be from then USA, he may be from China, whatever it may be, right. But import does not give you any right, right. So, that is important thing. The second what we can say, the act says that who have communicated from outside India, that communication, that first communication about that invention also does not say that he is a true or first inventor. So, that is very clearly what we can say mentioned in the act, who are not the true or first inventor. Importer or who have done the communication, they are not inventors. Okay. Person includes government. Now, what is the definition of assignee according to act? Assignee includes the legal representative of a deceased assignee, and references to the assignee of any person include references to the assignee of a legal representative or a assignee of a person. Okay. Now, legal representative is what? The person who in law represents the estate of a deceased person. Legal heirs may be there, or whatever according to will, that whosoever is a legal representative, that have that particular right to do whatever they want to do with the property. IP is a property, so legal representative will decide what they have to do. Who is a patentee? Patentee means the person for the time being entered into the register. So, why it is called as a time being? Because what the thing may happen is that suppose today somebody filed that patent and all that thing, all process completed, grant is that grant is the patent received grant. Now, patent is X. Okay. The what we can say, the after 2 years, the possibility is that that patent will be assigned to someone else. That is a possibility. Then at that time, what will happen? That ownership changes, right? Assignee is the owner. Inventor will not change definitely, but in this legal transactions, assignee may change because the rights of ownership. So, I will give you the example so that you can easily appreciate this thing. Suppose you own a flat, right, and you are the owner of that flat, right. So, your name will be there as a owner for that particular flat. After 5 years, suppose you sell that flat to someone else, registration will happen and that ownership of that flat will be transferred to from you to somebody else. So, what the thing has happened? The ownership is changed. Similarly, in patent, the possibility is that today patent is on the name of X organization. After say 3 years, some acquisition happen, or some what we can say the sale of that particular patent may happen. Some inventor is a assignee sometimes, and inventor license that thing, or no, I should not say the license, I should say that sale that patent. If inventor sell that patent to somebody else, then obviously the ownership is completely transferred, and then what the thing will happen, the assignee will change. Okay. So, patentee is the person for a time being entered on the entered in the register as a grantee or a proprietor of a patent. It may change, inventor never change, right. We have invented the thing, that will be as is. So, inventor and assignee, assignee is the owner and assignee gets all rights. So, now you know that first page of patent, it gives you all bibliographic information, and there you have seen that in name of inventor along with address is always mentioned on the first page. Then there is a name of a assignee, and we have seen one example of a patent from the Xerox Corporation, right, and Crawford et al. Was the what we can say, he was inventor for that particular invention. That one example we have seen when we have seen the parts of patent document, and then for a Xerox we have seen the another what we can, 3 inventors were there. Okay. So, on that first page only you can realize that who is an inventor, who is a assignee. So, this is one thing, that is identification. Second important thing, remember that inventors will never change, assignee may change, important. The third important thing, ownership is with the assignee, all legal rights are with the assignee, inventor do not have any legal right when we are talking about a patent. Okay. Fourth important thing, is it possible that inventor and assignee will be same? It is possible. So, inventor and assignee both can be same, right. So, same inventor files that patent as a assignee. So, the possibility is that both are same. So, fourth important thing. So, next thing is that what is how the number is determined, how many numbers can be there under the what we can say inventor. There is no any limit, we know that thing. So, there may be 1 inventor, there may be 10 inventor, it is, that is fine, you have to write down every details of everybody. Okay. So, that is a fifth thing. Now, suppose now how the things happen in the corporate or in the organization. Suppose IIT is a what we can say assignee, and there are 3 inventors, and if IIT successfully do the technology transfer of that particular patent, and if they want to share the royalty which is received from that particular transaction, then how things work, who will determine, whether patent office will determine that thing, that how much share should be given to inventor? Not at all. Patent office is not at all involved in all these things. Patent office has, you have just mentioned there that okay, who is the assignee, who is the inventor, patent office has clearly mentioned all that things. Now, assignee is a what we say that it is a owner of that thing, all rights are with the owner, owner will decide what the share should be. And so, it is always suggested, and you should remember this thing, that when the patent will be filed, when it is considered for the filing, what we have to do is that at that time only it is better if there are 5 inventors, better you note down the contribution share, right. So, maybe the possibility is that some person have contributed more, 60% may be his contribution or her contribution, and remaining 40% will be divided into 4 others. So, whatever that sharing is there, it is always better to clearly mention that thing, right. So, this is what the inventorship and then the assignee is, whatever the assignee is. So, I guess you got pretty well idea about inventor and assignee. So, we have seen that who are not included in true and first inventor, that is first importer, or who have first communicated are not inventor. Then we have seen the definition of patentee, we have seen the definition are who are the legal representative, who is a assignee, and who is a, we have seen that a government is included as a person, right. So, we have seen this definition. Now, what are the rights which are given by the patent office or by the, whenever you are getting grant, what rights are awarded, right. We know what that rights are. The owner, that is a assignee, gets the exclusive rights, right. So, what that exclusive rights are there? To prevent third parties from making, using, selling, offer for sale, or importing. All these rights are given by that, these exclusive rights, making, using, selling and offer for sale and importing, all these rights are given to the owner, right. Now, if the subject matter is process, that whatever the processes are there for making, using, offer for sale or importing or selling, all that what we can say that are given that to the process related thing, if it will be given to the, that whatever the processes are doing all that thing, obviously all rights will be given to that. If product is there, so for making that product, for using that product, for selling that product, all rights will be given. So, depend on what that patent is, whether it is a process or a product, obviously your rights are for making, using, selling, offer for sale and importing, right. Who is getting the right? Assignee. Inventor is not getting the rights. We have to just remember that. Inventor is the rights, or the what exactly then inventor gets. It depends on the who is a assignee and what is the policy of that organization. So, that may be appreciation, that may be promotions, that may be some monetary benefit. So, it depends on the assignee, who is a assignee, that will determine what share or what will be of what should be given to the inventor. If both same, then there is no issue. But if any organization is there as an assignee, then IP policy of that organization determines what are the benefits which will be given by the inventor. But whatever the condition is there, inventor will never change, assignee may change according to, if any transaction happen, that assignee may change, that we have seen. Okay. And these are the rights, that is a making, using, selling, offer for sale, importing for a limited period, 20 years, that we know. Okay. So, after knowing all this thing, that is who is assignee, who is inventor, where you get the information, I guess you have got a pretty well idea what is the difference between inventor and assignee. Remember well, assignee is the owner. Okay, all things you know now. Just after going all this thing, you just enjoy this video.
Over the last few decades, the Patent and Trademark Office has dramatically increased the number of patents it has issued. At the same time, patent litigation has increased dramatically.
Alex Bloomberg of our Planet Money team and NPR's Laura Seidel have this report on a patent system that's been turned on its head.
When you talk about the patent system among techies in Silicon Valley, there's usually an audible groan.
If I say patent system, what do you say?
I think it's just a way for lawyers to make money.
Josh Malone, inventor of Bunch of Balloons, a device that allows you to fill 100 water balloons in a minute, had some trouble enforcing a patent for his invention. Josh invented the product and ran a very successful Kickstarter campaign in 2014.
It was very easy to copy, and it was quickly copied by a company named Telebrands, who started immediately selling a copycat product. And within the first year of them selling the copycat product, they made $40 million just off of their own infringing product.
Even though the patent office gave Josh a patent for the invention, he found himself having to defend the patent again and again in the PTAB, a court within the patent office.
Josh Malone actually has 6 issued patents that I'm aware of, and they all relate to the Bunch of Balloons. And Telebrands has filed 8 petitions for what's called post-grant review at the PTAB.
If your product's worth tens of millions of dollars, you have to have the resources to fight it, and because the patent's just not straightforward to enforce.
Josh ended up in the middle of a broader public debate about what patents should be granted and how those patents are to be enforced.
Innovators like Josh need patents. They need them in the way that everyone sees every week on the show Shark Tank, where the venture capitalist asks the inventor the very first question, do you have a patent? And sometimes they say no, and the response is, are you insane? You just went on national television and gave away your idea. There's no way we're going to invest now in you thousands, if not millions of dollars.
There are huge problems when patents get issued by mistake because it prevents the entire public from exercising their knowledge over the invention or using their knowledge over the invention.
So this is a big debate that's currently going on in patent law, in patent economics, and patent policy of how do we tailor property rights in patents that actually do promote innovation.
70% of my revenues go into litigation.
why has Josh encountered so many problems with enforcing a patent for bunch of balloons? And how has that affected his work?
With this, we come to the end of this session. See you in the next session. Thank you.